This morning in Case 12-842, the Republic of Argentina versus NML Capital Limited. Mr. Blackman.
Mr. Chief Justice, and may it please the Court, the sweeping worldwide forensic examination of foreign state property that the Court of Appeals approved targets sovereign property that the FSIA makes categorically immune from process of U.S. courts, including diplomatic and military property, national security assets, property of a state's current and former presidents, and other property outside the United States. This far exceeds the enforcement powers of U.S. courts under the FSIA.
Aren't those issues of privilege? And didn't the court below permit you to raise those questions as individual items came up, as individual accounts? Because the subpoena is only asking Bank of America or the banks for their information. Some of them may be of that nature. But wasn't the district court going to monitor that?
Well, two answers to your question. First, Justice Sotomayor, the FSIA comes logically and legally before issues of privilege as to a specific asset. There's a categorical limitation of execution and all process in aid of execution to property in the United States used for commercial activity.
That's on what you can execute. FSIA itself doesn't say anything about discovery.
The FSIA doesn't have a provision, except for 1605G, which specifically talks about discovery, but the statute very much delineates the bounds of permissible discovery when it delineates the universe of executable property. The legislative
in an ordinary state case, let's say, you get a judgment in New York, and the judgment is not satisfied, and so there is this kind of an inquiry into what property the losing defendant owns. Cannot you find out what property that defendant owns in Florida?
In Florida, certainly, yes.
But the New York court has its writ does not run to Florida.
The way rules
you have to bring another lawsuit in Florida, right? And so also here, the writ of the Second Circuit doesn't run to France. You may have to bring a separate suit in France, but I don't see that it goes beyond the bounds of what the law allows the discovery to cover.
Well, Rule 69, which has never been construed in the area of discovery in aid of execution by this Court, provides for discovery in aid of execution. And in aid of execution logically needs to mean the execution that could be ordered by the court ordering the discovery.
But that's absolutely not true, because a New York court cannot order execution on property in Florida.
Well,
you have to bring another cause of action in Florida, and yet you certainly can find out what property the deadbeat defendant owns in Florida.
Rule 69 also says specifically, Justice Scalia, that it is subject to a federal statute that governs where applicable. And the advisory committee notes clearly list a whole host of exemption statutes.
You're saying that you can't inquire into property that would be exempt anywhere. That's the difference. You may have to bring a separate suit in Florida, or probably if it's a federal judgment, you just register it there. But in the typical case, the judgment debtor is exposed, all of her assets are exposed. Here, I think what you're saying is the statute, the Foreign Sovereign Immunity Act, confines what can be executed, whether Florida, France, any place. It's got to be property, commercial property in the United States.
That's exactly correct, Justice Ginsburg, and I was referring to the exemptions that are listed in the advisory committee notes because they list things like homestead and veterans benefits and other categories of assets.
What's the reason? I mean, I read this like Justice Scalia. I thought when you read Rule 69, obtaining discovery, you can obtain it in aid of the judgment or execution as provided in these rules. So you look to the rule on discovery, it's certainly broad enough to encompass this. I thought, of course, you can get discovery in an appropriate case to find out if the judgment creditor or debtor has property in Florida. And the question is, well, can you do the same thing where the executable property is in France? And I think that's the issue, at least as I saw it. And I don't see, well, there are three ways of doing it. One, you could just say no. Two, you could say yes, but the State Department has to tell you it won't mix everybody up. Or you could say yes, but the State Department has the right to come in and tell you it will mix everybody up. Well, I mean, those are three possibilities. Or you could say, let's mix them all up. All right, those are the four, and in other words, the Court can just do it on its own. So I see four possibilities. Now, maybe I'm not analyzing it correctly, but that's where I was, starting where Justice Scalia started.
If I could respond to some of those points, Justice Breyer. Talking about the State Department brings us back to why do we have this statute? We have this statute to avoid ad hoc judicial or political interventions. Before the statute, there was absolute immunity for foreign state property.
I know, but to sort of shorten this, I understand there's a statute. The statute says nothing about discovery. The statute does permit you to execute on property within the United States anyway, and it does that under exceptions which are relevant here. For example, in the back of the bond, they said we waive all sovereign immunity. So it does allow for execution in the United States. It does, in fact, say nothing about discovery in aid of execution. The rules do. Okay, so I've given you four possibilities that I could see. There may be five or six. Which do you favor? Why?
I favor saying that in aid of execution means in aid of execution permitted by the substantive law. There's no statute that we've thought of or could find where discovery is untethered from the substantive provisions of the statute. Here,
do you contend that you cannot levy upon commercial property in foreign countries where those countries have the same kind of Foreign Sovereign Immunity Act as we do? When you get a judgment in New York, can you take that judgment and levy upon commercial property of Argentina in France?
To the extent and only to the extent that the judgment would be recognized by a French court.
Of course.
A U.S. court could not levy on them.
So you are entitled to find out what property Argentina has in France, and your only complaint is you shouldn't be able to find out what property that is not subject to the Foreign Sovereign Immunities Act is in France, right?
Well, the property that's subject to the Foreign Sovereign Immunities Act is only property in the United States used for commercial activity.
But you acknowledge that you can levy on property in France. You can take your New York judgment, go to France, and so long as the property is commercial property and France has the same at it, which it does, the same modern rule that sovereign immunity does not extend to commercial property, you can satisfy your judgment in France. Right?
That's a matter with respect to French law and what the French court would permit.
That's fine, of course, but that doesn't mean you can't find out and go to France and roll the dice in France, right?
Well, we would suggest
you're saying you can't even play the game.
Well, no, we're saying that the way you play the game is to do what the respondent here has done for many years, which is to pursue discovery of property in the United States that's executable by the process of a U.S. court. But if it wants to go abroad...
I can't understand this. You acknowledge that you can go after property in France, but you assert you are not entitled to find out what property Argentina has in France.
That's a function of a statute which deliberately circumscribes the normal powers of a court.
I suppose I don't see exactly the same question. Is the only reason that you cannot ask a New York court for discovery to tell us where in the world there is property upon which we can levy? They don't want to know about property where they can't levy. They don't want to know about property they can't execute, so they're happy to write into that, even if it isn't written, which they think it is. We're only talking about property that we can seize, no other property. Now, you agree that we can go do that in respect to property in California, Florida, and New Mexico. Well, in today's world, we want the same information about France, Italy, and Turkey. And by the way, we won't take 1 penny from those countries except in accordance with the law of those countries. Not a penny. We'll get the information, we'll go over, and we'll ask the court. Now, why not?
The reason, besides the language of the statute, is comity.
No, I didn't find language in the statute that forbids it, but I'll look that up again. Okay. If the language is not an absolute barrier, why not?
Well, first of all, the order here, Your Honor, isn't limited to property that's executable.
All right, let's assume we go back and we say it has to be limited to property that they have a right to obtain to under execution. So we all agreed between the two of us